Good afternoon. My name is Ron Weich. I'm the Dean of the University of Baltimore School of Law. I'd like to welcome you all to this first installment in our UB Law in Focus discussion series. We are really excited to be offering this series of webinars to examine current issues through a legal lens and tapping our very accomplished faculty members and alumni to participate in these conversations. There's so much going on in the world at the moment. And as I reflect on the role of our law school, I come back to the fact that we are an educational institution. We educate students, certainly, but I also want us as a public law school to be broadcasting our views and our understanding of legal and constitutional issues to alumni and members of the public and others. So glad to be continuing this discussion series to educate the wider community. So three most insightful, opinionated, and thought-provoking colleagues are with us today, and I'm going to introduce them shortly. But I want to emphasize this is an interactive discussion, and we welcome your questions and comments. And to participate, you should use the Q&A function of Zoom. So at the bottom of your Zoom page, I think we're all getting used to this, you have the ability to click in and type a question, and I will be moderating the discussion, and we'll watch for those questions as we go along. We'll get to as many as we can. We'll participate in this discussion for at least an hour. Maybe we'll go just a little bit over if there are enough questions. And before we get started, I want to let you know about the next webinar in our series so that everyone can prepare. Next Tuesday, we're going to discuss the culture of policing. It will be called To Protect and Serve, Changing the Culture of Policing. And we'll be joined by our colleague Mike Higginbotham, who's a noted civil rights scholar, as well as UB Law alumna Kim Neal, who is currently the Police Oversight Director for the city of Fort Worth, Texas. We may, in addition, be joined by another UB Law professor, but we'll be looking at some of the concrete steps that should be taken in response to the death of George Floyd in Minneapolis and other examples of excessive force by police departments. You'll find registration information for that webinar on our alumni page of the UB Law website, as well as on the website's events calendar. So now, for this evening's presentation, the topic is Constitutional Issues in a Pandemic, the Obligations and Limits of Government. But as you'll see, we're going to broaden that a little bit with our three wonderful panelists, longtime UB Law professors, Garrett Epps, Mike Meyerson, and Kim Wehle. Let me introduce each of them briefly. Garrett, I should actually introduce as Professor Emeritus because sadly, just a couple of days ago, he retired from the active teaching faculty, but he remains a member of our community as Professor Emeritus, and he assures me he will not be a stranger to our law school. We're very grateful for that, because you know Garrett is a wonderful member of our community and writes so prolifically about the Supreme Court in the Atlantic. He's written books, including American Epic, Reading the U.S. Constitution, and To an Unknown God, Religious Freedom on Trial. Mike Meyerson joins us. He's also an author of a book about the freedom of religion. It's called Endowed by Our Creator, The Birth of Religious Freedom in America. And we congratulate Mike, who recently received the prestigious University of Baltimore President's Faculty Award for his tremendous contributions to our law school and to his students. And finally, we're joined by Professor Kim Wehle, who is the author of, most recently, How to Read the Constitution and Why. And later this month, she has another book coming out called What You Need to Know About the Right to Vote and Why. So we look forward to a discussion about voting rights later in this discussion series. Kim writes as well for publications such as The Bulwark and The Hill and Atlantic. She's a frequent TV and radio analyst on constitutional matters. Now, as I said, I want to broaden this because there's so much happening even in the midst of a pandemic. We see massive demonstrations in the streets of American cities in response to the killing of George Floyd and other perceived examples of police misconduct. Really, this has broadened to a critique of lots of aspects of society. And I want to know from our three experts, what is the ability of government to respond to this and who has responsibility? So let me begin with our elder statesman, Garrett Epps, who wrote recently in The Atlantic, I think just yesterday, about the right to protest and how it relates to government authorities to limit such activities on the streets. Garrett, how do you see the current situation?
Well, the First Amendment has a very important passage that's not quoted as often as others, but the right of the people to peaceably assemble and petition the government for redress of grievances shall not be abridged. And what that means, if it to mean anything, is that presumptively when you have people together in a march or a demonstration, that is presumptively protected behavior. Now, if people on the fringes begin to engage in violence, they should be arrested. But the idea that, and we've seen this on the streets of our cities, that the police or the government or the president can simply just say, this is an unlawful assembly, you have to disperse. Our constitutional tradition doesn't allow that. Sometimes violence is so out of control that government has to clear the streets. But you can't just clear the streets because you want to dominate the battle space. And I think we are really in danger of seeing gross violations of a very important right.
All right. So let me turn then to Kim Wehle, who has also written recently about this subject, and she examined in the Bulwark, she dusted off a very old statute, the Insurrection Act. What is it date from, 1806?
1807, yeah.
1807, I missed the year.
Yeah, close.
I wasn't around. So Kim, tell us about that act, because it seems to give the president a lot of authority, and I wonder if it bumps up against Garrett's observation that generally people have the right to protest.
Well, all of these constitutional provisions, most of them come down to some kind of balancing of interests, individual rights on the one hand, and the need to protect the public on the other. Some derive from this Constitution, some come from an act of Congress. And as you mentioned, this statute's been around for a very long time, and it's been used by many presidents over many, many decades. It's never been challenged for its constitutionality. But President Trump indicated on Monday that they would bring in federal troops to start addressing these protesters. Some have been brought to DC already. And when you look at the statute, the authority is actually quite broad. The last time it was used was in connection with the Rodney King beating in California. But in that instance, the governor asked for help. He said, we need help. We need reinforcements. Federal government. In this instance, that's not always the case. The statute does allow the president to use the words to suppress any insurrection, domestic violence, unlawful combination, or conspiracy if he believes that either federal or state law is not properly being enforced. But it's important to keep in mind here, under the 10th Amendment, the police powers go to the states. States are the ones, state cops, state sheriffs, the patrol officers you see on the highways, that they answer to the governor of the particular state. The military is trained to go after the enemy. It's a completely different mindset. And so it's very, very rare. The concept of anti-military rule goes back to the Magna Carta of 1215. It's as foundational as we have of anything. It has to be used very gingerly, and I think it's extremely significant that the Secretary of Defense, appointed by the president, Mike Espy, basically made a statement saying, I do not think it's appropriate. I don't think it's appropriate. I'm sorry, Esper. Thank you. Yeah.
The White House says he remains Secretary of Defense as of this time. That is the official quote. So keep your fingers crossed.
We'll update our audience if there are developments there. But let me turn to Mike Meyerson, because Kim Wehle observes that in general, governors have police powers, mayors, governors have the ability to, enforce criminal laws, for example. And yet the president said some weeks ago, before the protests, but when we were in the pandemic situation, the president said that he had total authority. Those were his words, total authority to take action to decide whether people should be, sheltering in place or otherwise reacting to the pandemic. What's your sense, Mike, as a constitutional law professor, of the line between the president's authority and the authority of governors and mayors?
Well, in general principle, there are a couple of things that are just fundamental to the American system. Number one is nobody has absolute power. Number two, whoever has power is answerable for abuse of that power. And number three, all power must reflect the spirit of equal protection of law. So that's your starting point. It's not a king. It's no one, from the police officer to the president, has unlimited power or the power to discriminate. what Kim was saying a moment ago is absolutely right. The line drawn by the 10th Amendment is a flexible one, depends on many things, not least of which is what Congress tells the president can do.
But we teach our students about the Supremacy Clause. And if there's a dispute between federal authority and state authority in general, the federal government trumps, pardon the expression, the state action. How does the Supremacy Clause relate to what you describe as shared authority? Nobody has total authority. Because
the Supremacy Clause only kicks in for rightful application of authority. It's not a whatever I do wins, it's whatever I do within my power is right. And remember one other thing, there are two divisions of power in the Constitution. One is between the federal and state, and second, within the federal government. So President Trump saying he can do it by himself actually often violates both principles of division.
Right, sometimes we think of that as horizontal division of responsibility and vertical as between the branches of government. Kim, you and I were talking about that the other day. The president says he might withhold funds from Michigan, for one reason, and from California for another reason. Does he have the authority to just withhold funds?
Well, that's with respect to voting, he indicated that I'm going to retaliate against states that are trying to expand voting to mail-in ballots and other options by withholding appropriations. That's a bit complicated, and you probably, Ron, as an expert on legislation, know a little bit more about that. But of course, the appropriations power comes from Congress. Congress gives a bunch of money to agencies. Agencies can use it. Likewise, money goes to the states. But as far as voting and electoral process goes, it's basically down to the states. The states decide independently what procedures they want to use, and he doesn't have the authority to say, I'm requiring the entire United States to vote in person, notwithstanding the dangers of COVID-19.
I mean, sometimes the president talks about Article 2. I think he's not a lawyer, but some lawyer must have told him about Article 2 of the Constitution, establishing
yeah, or the lawyers during the impeachment trial, right, who really, I think, overstated the position that their suggestion that the Article 2 power is unlimited. The notion that the president, so long as in his mind believes that what he's doing is for the interest of the public, there's no basis to impeach him for it, and he can't violate the law. That, of course, was criminal law professor Alan Dershowitz's position in the closing statements during the impeachment trial. But of course, if the framers were okay with a monarchy, we would not have had a revolution and a United States Constitution. So that is as basic as it comes. You don't need to be a constitutional law scholar to know the president's wrong about that. His power is limited. But as I say, oftentimes it's like if there's a speed camera hiding behind the bushes, you slow down. Otherwise, you might not. The fact that the law is there doesn't manage the behavior. What matters is if there's a consequence for violations. And in this moment, this president has acted in a way where there's no real consequences through the other branches of government for his behavior, and that's why we're seeing it escalating in part.
Garrett, what kind of accountability, I think that's a good word that Mike used and Kim has echoed, what kind of accountability should there be on a president who is kind of swinging for the fences here?
Well, going back to the question of him trying to seize control of voting, the power to set rules and regulations for voting, of course, belongs to the states. In the first instance, Congress can make rules for federal elections. There's no role for the president. And one would hope that if the president attempts to do it in some official way, that the courts, the third branch of government, would say, you don't have this power. Now, a lot of people are beginning to despair of the independence of our courts. There's been a real concerted assault on the courts as a independent branch of government. But, it's that or impeachment or defeat for re-election. And if he starts to meddle with the election process himself, it's really either only impeachment or the courts.
Right. The Constitution didn't give us a lot of tools.
No.
I'm going to be the optimist here.
All right, go ahead.
Because number one tool is what Garrett talked about earlier, the First Amendment. We have voices. You see the First Amendment in play on the streets of America today. That's number one. Number two, the courts have a special ability that only tenured law professors appreciate, which is the inability to be fired. And I think what you may find is that attempts to pack the court tend not to work, at least to an extreme level. So I am still putting my money on the courts, and I'm still putting my money on free speech.
All right. Let's, we already have a couple of questions, and I'm going to open it up to one of these, and then I'll come back to some other questions that I have. But back to the question of protests, we have a question. Can public health or public safety be used as a reason to break up protests or demonstrations? I mean, we saw, I guess, Garrett, let me come back to you since you wrote about this. The president broke up a demonstration, apparently peaceful, in order to walk across the street from the White House to stand in front of a church with a Bible. But what if he said, you know, this is unruly, this is somehow dangerous? Would that enable him to break up the protests? And does the coronavirus change the way that states and the federal government approach these protests?
Well, there's two parts on that. And the more general question I'll start with, which is, you know, when does violence or unruliness or whatever it may be permit government to break up a demonstration and send everybody home? And there's precedent going back to the civil rights era that says if the violence is such that it can be handled by law enforcement, if the crowd can be managed, and which I would translate as, you know, violence on the fringes, then that's the job of law enforcement, is to deal with the people who are acting badly. The King of England or any of his servants had the power to declare any assembly unlawful and punish with death anyone who persisted in the assembly. We don't have that in our system. Now, the virus is a different question. And of course, we have regulations about assembly can be, if they're neutrally employed, you say, you know, it is very worrisome to see all these people crowded around in demonstrations. They're not socially distancing. We are risking seeing, you know, an uptick in cases in 2 weeks.
Yeah.
But on the other hand, it has to be neutral. And since we have a president who is insisting that the virus doesn't exist and everybody has to open up, it seems to me that there's a real question of pretext. If he says, well, yeah, okay, the virus doesn't exist and I won't wear a mask and everybody open up except that crowd over there that is inconvenient to me might be spreading the virus, then I think a reviewing court would exercise what is called the sovereign prerogative of philosophers, that of laughter.
All right. We have a question that maybe is best directed to Kim Wehle. One of our audience members wants to hear about the Unitary Executive theory, which is that support for the proposition that the president can do what he wants to do if he's the Unitary Executive.
Yeah, so we've heard a lot about this, particularly in connection with our current Attorney General, Barr. The notion is that the framers didn't have a panel to head the government. They had a single person. And the rationale is that in times of public safety or urgency, national security concerns, if we're at war, the president can't make decisions by committee. That's impractical. He needs to be nimble, be able to take decisions that maybe don't go through Congress, right? The second primary, there are many rationales for it. The other primary rationale is the famous, Truman comment, I think it was, the buck stops here, the idea that there's accountability that goes to the president. And I think this theory became really popular under George W. Bush II because John Yoo, then at the Office of Legal Counsel, now is a professor at University at Berkeley, justified the Torture Memos, the famous Torture Memos, on the notion that the president, when at war, cannot be overridden. We've seen this expand, that concept, under President Trump, that the president is always unitary and can't be challenged. There's some people promoting that. And of course, as I indicated earlier, that contradicts this notion of we're not a monarchy. And just one pin I want to put in that, the irony with this particular president. John, you wrote an article that there were two primary justifications for the Unitary Executive. I mentioned accountability. Of course, this is the anti-accountability president, where he shoved authority and responsibility for COVID to the states. The second is we're in an international pandemic. If the idea is nimble decision making, making decisions in the public interest rather than having all these jurisdictions, a patchwork of decision making, he didn't use it there either. So I really think this notion is falling apart in terms of its rationale under this administration.
All right. Well, I'm going to get back to some audience questions, but I'm curious, and I'd like to address, especially to Mike and Garrett, since you've written books about this, the issue of freedom of religion in a pandemic. So the president has said that he wants churches to be open, and some churches have asked to be open, even though it's a place where a large number of people congregate, often indoors. Mike, let me turn to you first and ask, since you've written about the framers' understanding of freedom of religion, is there anything to the president's thought that religious services are entitled to special consideration in a pandemic?
Well, there are a lot of ways to go. And number one, I just want to start with George Washington, who's always a good guy to start with, who said there is no force in government more divisive than religion. And I think the idea that religion can ever be used as a political dividing line has been shown by centuries of evil and modern world as well to be an incredibly dangerous thing to do. So we start off with the idea that we don't want government to use religion to divide us. On the other hand, we do very much believe that religion has a special place in the Constitution and a special place in America. What that means is that if you're going to single out religion, you're allowed to in this format of, it's called accommodating, trying to make sure, that's why you can have no parking in front of a church on Sunday. In terms of the bans on people meeting, there must be a reason to treat churches different than the places that are open. Now, there's a problem here because not all religious institutions are the same. They don't all have the same size, the same membership, the same length of services. But you can certainly distinguish a supermarket where people are in and out from a religious institution. I think there's been a bit of overdrafting, if you will, that to say no religious services at all and allowing other groups to meet indoors would be incredibly problematic.
Mm-hmm. Garrett, tell us about that Supreme Court opinion. There was one case that worked its way all the way up. It's South Bay Pentecostal Church versus Newsom, Governor Newsom in California. Tell us how that case came out and how you think that issue will progress.
Well, the background of this case is a movement by the Supreme Court to a special place for religion, a special favored status, and that takes the form of saying that religion's being discriminated against. So in the Newsom proclamation, in the rules, certain businesses were allowed to operate, in phase 3 or whatever it may be, and churches were delayed until phase 4, until a certain epidemiological state of affairs occurred. This went to the Supreme Court. The churches said anything that regulates churches discriminates against churches. So that if you allow any businesses to be open, you have to allow church services to take place. Well, the fact of the matter is there are factual differences between a grocery store and the way people use it, or a drive-through at a liquor store or a restaurant, and a church service where people come and they stay in person. They stay for as long as an hour or 2 hours, breathing the same air. As we know, the virus can travel. And so there was no evidence to me that this was discriminatory in the sense that it was regulating religious groups because they were religious. Nonetheless, the Pentecostal Church got 4 votes in the Supreme Court, and Justice Kavanaugh wrote what I thought was a thoroughly dishonest opinion, saying, if religion is ever treated differently, it's clearly discriminatory. This is anti-religious animus. It really was like propaganda from one of these conservative religious groups. And it kind of chills me because, there are obligations that religious bodies have. And one of them is not to spread deadly diseases, if they can avoid it. Now, Mike said there's some overreach. Yeah, I think the things in the South that said you can't have a drive-in service, that might have been a little bit of an overreach. Whether it reached the level of a constitutional violation that the Supreme Court should step in with is a different question. But I think the Supreme Court case came out right in saying, we're going to leave this in the first instance to the governors, and you have to prove some pretty serious, real discrimination before we're going to allow you to set aside an emergency proclamation from the governor to stop a contagious pandemic.
Yeah, interesting. You're right. It was a 5-4 decision. So the lineup is kind of the traditional conservatives, if you will. Kavanaugh writes the dissent for himself, Alito, Thomas, and Gorsuch. And it's Chief Justice Roberts who's with the, well, some call the traditional liberals, appointed judges. So that's he provides the 5th vote to say that the governor can have restriction. This is now a little bit off topic, but are we feeling like Chief Justice Roberts is becoming a little bit of a wild card? Kim, you keep.
I pray for his health.
Yeah, defibrillators all across the board in the Supreme Court.
Right.
I think if you read Justice Roberts' opinion, one of the things that really was bothering him was what we've been talking about, the idea that states have the prerogative to make these decisions in the moment. And the drive-in church cases, for example, courts were upset with those pretty early on, and the states adjusted. I mean, we've never had a COVID pandemic before. Governors and mayors are doing the best they can for the most part, and it's a bit of a trial and error. No one is nailing it right? We have 104,000 deaths. That's clearly not a success. But I think he did the right thing in saying, the court shouldn't come in and second guess and start becoming governors. And back to our original point about how the separation of powers and federalism is kind of falling apart as a check on the presidency. What's also happening is the courts are becoming government. And that's not the way it's meant to be either, because the other branches aren't working in the way I think they were meant to work or traditionally meant to work. So I think Roberts did the right thing, and this conservative court has jumped the gun in many cases and been quite strong-armed a fair amount, that you would think the notion of judicial restraint would keep them out of the fray unless they're absolutely required. Because remember, they are not elected and they're there for life. So they don't answer to the people. They're inherently undemocratic. And the theory is, as Professor Meyerson indicated, if they're there for life, they're not going to make decisions based on politics. They're going to make them based on facts and the rule of law.
There's something else. There's a historical imperative about courts, which is, since Richard Nixon started putting people on the court, we've been told that all these rights would go away. And without question, certain rights have been limited, but there have been really very few truly major rollbacks of the fundamental rights we've been talking about. And the court is, in its own way, inherently conservative in the small c, non-political way. And Ronnie made an excellent point about Roberts' role in here. I'm not trying to call him even the wild card, though. I think he's an institutionalist, and he wants the court's reputation to survive the political, nonsense.
All right. I want to talk about a right that maybe is in somewhat danger, and it's the right to reproductive freedom. And it's, in a sense, I'm going to flip, as law professors like to do. I'll do it to these law professors, to flip the question, because we all just said in relation to religion that the courts shouldn't second guess the governmental authorities, the government and the legislature. Well, in Texas, the governor wanted to, he said in response to the pandemic, that he wanted to conserve medical equipment and resources, and therefore he was going to limit elective procedures, including what he considered elective, abortions. And it went up to the courts, and ultimately it was resolved, kind of settled, as the governor pulled back. But how do we see that? I mean, should the court be deferring to the governor of Texas, who says that abortions aren't so important? Kim?
Oh, so it's not just Texas. There have been a number of states that have used, critics say, have used the coronavirus as a justification to clamping back more on abortion rights. And I think when people think about Roe versus Wade, what they don't realize is there are later cases, Planned Parenthood versus Casey, where the court essentially put a balancing test and said, you can infringe on a woman's ability to get an abortion so long as it's not an undue burden, without defining what the word undue burden means. So this has been a steady restriction of abortion rights sort of tinkering at the edges as a practical matter, particularly for low-income women. They can't get abortions even with Roe versus Wade. Now, with respect to COVID, that balancing would come into play. What is this an undue burden? And I'm not a doctor, but studies have shown that actually carrying a child to term and delivering a child is more dangerous to health. So the notion that not taking care of that, so long as it's authorized, is somehow not relevant to women's health or not an undue burden. Of course, it's more complicated later in trimester. That doesn't really hold water, particularly unless there's a real showing that these hospitals were overburdened with abortion procedures. They were using ventilators and ICU beds, and therefore couldn't accommodate people living and dying. And the court's recent case in this whole Women's Health versus Hellerstedt in 2016, the court did strike down a law saying this isn't even passing the undue burden test. So I think, as to use a technical legal term, I think it's getting a little bit cute to say we need to cut off abortions completely in order to serve the public interest and protect against COVID infections, particularly when we're not seeing the kinds of contact tracing, mandatory masks, and testing that we're seeing in other countries like Iceland, Germany, that did it early, and they're having many, many fewer cases. Government saying, we're not going to do that because that infringes on rights, but we are going to stop abortions. It just doesn't pass the basic intellectual honesty test for me.
I'll ask
Ron,
Garrett,
if I could,
please.
yeah.
Go ahead.
I think one of the things this particular case reminds me of an old story about Abraham Lincoln, who said to one of his cabinet, how many legs does a cow have if you call a tail a leg? And the guy said, well, 5, Mr. President. And Lincoln said, no, wrong, 4, because calling a tail a leg doesn't make it a leg. And calling an abortion elective surgery doesn't make it elective surgery because of the time factor, right? This is not having a mole removed. And every day that you force a woman to wait to get an abortion increases the risk to her. And the other thing to understand is most elective surgery is not guaranteed by the Liberty Clause of the 14th Amendment. Women still today, now I don't know how much longer, but still today have a constitutional right to seek abortion. And to say, well, it's elective, and so we're just taking that right completely away from you until further notice, I think is the definition of an undue burden. It completely thwarts a woman's decision. So if the court is, the Fifth Circuit has already overruled Roe versus Wade, but if the Supreme Court is playing without marked cards, they are going to not let that stand.
I think one of the sort of keys here to distinguish it, Ron, from your point of the religion, the church bans, if you will, is that there's no doubt that none of the governors who shut down the churches were hostile to religion. No one was saying it. No one believes it for a moment. We all sort of suspect, though, that the governor of Texas was very much motivated by a desire to limit abortion. And if I can go to the right-hand side of our political world, those governors who wanted to shut down gun stores were probably motivated similarly. And I think you need justification. What makes something different? Why is a liquor store open and a gun shop not? And I think that when, as Garrett said, when we're dealing with constitutionally protected rights, we really want our governments to prove limitations are needed.
Right. Let's go back to the questions from our audience. And there seem to be several questions about, again, presidential authority under these unusual circumstances. Our faculty colleague, Tim Sellers, appears to be watching. Hello, Tim. And he types—
Hey, Tim.
Hi, Tim.
Tim says, what powers does the president have under the US Constitution to address emergencies, such as pandemics or insurrection? Are there inherent executive powers that attach to executives everywhere? So this takes us back to the earlier part of the conversation. But I think Tim presses the point about maybe Article 2 or other inherent executive powers. Do you see anything in the Constitution that is kind of inherent to the guy in charge? Kim?
Well, I mean, with the commander-in-chief power, perhaps. I mean, the authority to execute the laws or take care that the laws are faithfully executed. This also gets back to this concept of unitary executive. It's not expressed in the Constitution. And, we also hear all the time on television and in news outlets about, strict reading of the Constitution, and liberals read the Constitution too liberally and read stuff in the living Constitution. Guess what? The Constitution's really old, and it's pretty vague. There's a lot of ambiguity in the Constitution, and the unitary executive theory is one place where that ambiguity is filled by a particular ideological and a viewpoint and or an approach to constitutional interpretation. So my colleagues might think of other places where you could lodge inherent ability to step in terms of a pandemic, but there's nothing expressed.
Garrett, you have a thought on this?
Yeah, I think it's important to understand that the whole unitary executive heresy arises from the first three words of Article 2, which is the executive power. Now, as I read it, it's the power to execute the US Constitution, laws which shall be passed pursuant to it, and treaties made or which shall be made under the authority of the United States, Article 6, Section 2, defining the law. But the unitary executive theorists say, no, it's every power any executive has anywhere, unless the Constitution says he doesn't have it. And so I always joke that, the president has inherent authority to change the weather with his mind, because it doesn't say that he can't. And I think if you read the Constitution as a whole, it's very hard to find extensive emergency powers in the Constitution. There's no provision for a state of emergency, which many constitutions have. And the one emergency measure that's allowed, the suspension of the writ of habeas corpus, is kind of carefully limited and pretty clearly lies in the final instance with Congress. The president may do it, but as Lincoln did, immediately seek authorization. So, the idea that the president can say it's an emergency, I have powers, inherent powers, I don't see the notion of inherent powers doesn't sit well with the philosophy of a written constitution and in Article 6, Section 2.
So Mike Meyerson, I want to come to a constitutional law landmark case, Youngstown Steel. We talk about that a lot. As I understand it, that involved President Truman trying to get more product, more steel out of the steel mills. And he asserted some presidential authority to demand that these private entities produce more steel. How did that case turn out? And what does that tell us about president's inherent authority?
Hey, that's a Korean War case. So in the middle of the war, there was a threatened strike of steel mills, and President Truman announced that we have to make sure steel keeps flowing to the military, and therefore he's going to, quote unquote, take over the steel mills and make sure that steel keeps flowing. Two important points about that. Number one, he lost the case, and largely because he was doing it without congressional approval. One of the things we know is that if the president is acting against or without congressional approval, it is the lowest level of power he has. So number one, we don't want the president acting without Congress or opposed to Congress. Number two is one of my favorite quotes from concurring opinion was that emergency powers tend to kindle emergencies. The framers knew that if you tell a government you can do more in times of emergency, they're going to call emergencies all the time. And in that case, in fact, after Truman lost and the workers went on strike, there was absolutely no shortage. 55 days later, they settled the strike and nothing happened in terms of our war readiness. So the danger of giving a president emergency power is he's going to cry wolf all the time.
We saw that with the border wall, right? Yeah.
Yes, the transfer of funds to build the border wall. Now, how does this relate to the Defense Production Act? Early in the outbreak of the virus, people said the president should somehow direct companies to build ventilators or masks. That is a statute. That's not inherent authority. But does the Defense Production Act kind of give the president more oomph to accomplish what President Truman wanted to accomplish in the steel case? Anyone? Garrett, Kim?
Well, the Defense Production Act is actually used a fair amount for things like making sure Air Force One is running and making sure there's armored vehicles that are being produced. Essentially, it functions by executive order. It is a statute, as you indicate, and the president has a lot of emergency powers by statute, as Professor Meyerson indicates. Congress can hand off the baton of power to this president and enlarge what Professor Epps mentioned is the notion of the definition of executive. So the Defense Production Act allows the president to do a bunch of things, but primarily to prioritize contracts in some kind of time of crisis, to say, listen, we need to stop making widgets and start making ventilators. And the president did do that to some degree here. He did order N95 masks, he did order ventilators produced. So he has pulled a few levers of his federal power while at the same time basically rejecting any coordinated federal response, which given that the virus doesn't understand the difference between borders between states, it's going to travel no matter what. It's hard to have a unified patchwork response. But the Defense Production Act is something that has presidents use with regularity and was utilized, I think, properly here to some degree.
Mm-hmm. Others on Defense Production Act, Michael, Garrett?
I wanted to, oh, Garrett, you go first.
Well, I'll try to be brief against my nature, but the key to understanding this whole area is that Congress is really the star of the Constitution. And if Congress passes a law, they can give the president all the power of the federal government in a specific area, like defense production. But if Congress doesn't pass the law, it's very hard for the president to come up with some inherent reason why he has to do something. We should always look to Congress in the first instance when these questions come up. Sorry, Mike, go ahead.
No, I want to pick up something that Professor Wehle was saying a moment ago, that the virus doesn't respect borders. However, the Constitution would have given the power, ideally, to the president and the national government and Congress to fight a national plague. But because the federal government fell apart in this area, the states actually still had residual power. And the fact that more people are not dead is because of federalism, and actually governors around the country stood up where they should not have had to, but the Constitution gave them the power to be the fallback when the federal government failed.
Yeah, I agree. This whole episode has shown sort of the importance of federalism, the need to have the states as a check on federal power, whereas, sort of in the civil rights era, it was the states that were not necessarily complying with the laws and the federal government had to come in and enforce constitutional rights. But that balance, I think, particularly when you see what's happening with a certain party in Congress, really in lockstep with the president for political reasons, but that party at the state level making independent decisions on behalf of the governors, the citizens of that particular state. They're Republican governors that are doing things that are in defiance of the president in ways that we're not seeing in the United States Congress. And of course, a variety of views is really important to make good decisions regardless of politics.
I have a question from one of our audience members regarding the Defense Production Act. Was ordering meat packing plants to stay open a proper exercise of the Defense Production Act? Anybody have a thought? Garrett, you have an opinion?
Trump's view is if it says power on the page, I can do it. I think it's pretty clear that meatpacking plants aren't essential to the defense of the nation. But the DPA gives pretty much unreviewable discretion to the executive in making decisions like that. So, whatevs. I mean, I think Congress has to be really careful in these delegations of authority, and it hasn't always been.
Well, I think the question is an insightful one, because in my list of things that the president has done, I didn't include that. And the difference is, telling a manufacturer of, vacuum cleaners to make ventilators, is if they're already going to be in place, might be different from telling workers to go to infected areas where the cases are really high, as we know in the meat packing plants. So like with all of this, there is a balancing. There is an obligation of government and of everyday people to take into account the public good at large. We see a lot of these protests, my rights, and we do have rights, but those rights have to be balanced against the interests of our neighbors. And I would argue, I'm not sure what the legal basis would be, as Professor Epps mentioned, but I would argue that the president, if he was acting with integrity and making decisions based on the public interest, would apply the Defense Production Act in a way that took into account the health risks of workers in particular industries.
So absolutely.
But I would also argue we have federal laws on worker safety, and they have not been overruled. They are actually part of this system. So, and again, if you need to protect, for the defense, do something, that doesn't mean ignoring OSHA and the wealth of federal law and regulation that are already on the books.
All right, I continue to encourage our audience to type in questions to the Q&A. I know there's a chat going as well, and Garrett has very nimbly managed to respond to questions that have come in the chat, but use the Q&A function if you would, so that I can only look at one thing as I look at my screen. There are several questions about martial law and Posse Comitatus. You know, this current situation is causing us to dust off some very ancient concepts, things we haven't thought about in a long time. What is, address this to anybody, what is Posse Comitatus? Such a archaic term.
Well, we saw this in connection with building the border wall. When Trump didn't get the funding, then he shut down the government. That didn't work. And so then the idea was, could he use federal troops to go to the southern border and start building the wall? And then people drummed up the Posse Comitatus Act, which essentially says you can't use federal troops to enforce civilian laws, regular laws that aren't about the military. Again, they're there to protect and defend the country. They seek out the enemy, they defeat the enemy. It's a different mission than even a police officer. The Posse Comitatus Act, though, comes later than the Insurrection Act, and what we call the preamble, the beginning of the statute, says this only applies if there's not another statute that is more specific. And I think the argument is the Insurrection Act is an exception to the Posse Comitatus Act, so that doesn't, unfortunately, in this moment, even though it would govern in most other instances, in an emergency, the Insurrection Act is the number one statute, probably not so much the Posse Comitatus Act.
I want to riff on like martial law, though, the other half of your question. Because
Sure.
dictators forever have said, I have to take over, there's a problem, I'm going to stay in power, I'm going to cancel the election. As Garrett pointed out, the limited power to suspend things like courts' ability to hear cases, the writ of habeas corpus, is really for Congress. The president doesn't have the ability to say, I'm in charge and no other rights apply. The Constitution did not give it to a human being, but to Congress.
I just also want to make a point on martial law, just as a definitional standpoint. I think that means wiping out all other law enforcement, that the military would be the sole law enforcement mechanism in the United States, not the Insurrection Act, where the military comes in and supplements the states.
Now let me ask this.
Can I also say something,
Sure,
which is,
go ahead.
we actually have case law on martial law, right? And that's a case called, and I'm immediately forgetting it, but it's ex parte someone who in Indiana was preaching sort of pro-Confederate propaganda. And the local military commander said, under my emergency powers, I'm throwing you in the stockade. And when the case reached the Supreme Court, the court said, it may be that there is an authority in emergencies to suspend laws and put people in jail without habeas corpus. And then here's the key phrase, but where the courts are open and functioning, no federal official has the power to suspend or bypass them by imprisoning or punishing someone without due process. So, that has seemed until recently to be pretty clear, and let's hope it continues to be.
So you've all observed that there are these checks on the president's authority, the courts, as Garrett just said, but Congress, and I think Garrett used the phrase, the Congress is meant to be the starring player of the Constitution. Is it relevant that in the early days of the pandemic, the Congress couldn't effectively meet? They were reluctant to congregate, and now the House at least has adopted some procedures to vote by proxy. But should we see the president's power differently in a public health emergency that limits Congress's ability to do its job? Anybody persuaded that that augments the president's authority?
We're meeting right now.
Well, we also have the
I'm sitting here in Columbus. I'm sitting here in Howard County. No, all of that stuff written in the age before the Pony Express. We now have means of communication that just means that is just should not. Ron, you and I have had faculty meetings and votes. There's just no reason why technology can't be our savior here.
Yes.
Well, and as I said, we had this $3 trillion bailout package that has a ton of problems with it, particularly that we don't know where the money's going. That's another topic. But Congress did function, and I want to just highlight something for the audience, which is that Congress does have all kinds of internal rules, which Dean Weich knows a lot about, internal rules for parliamentary rules for how it functions. And that was part of the issue with whether they could pass legislation from afar. And as a practical matter, they're not in statutes, they're not in the Constitution, they're not in court cases, but they do actually have a tremendous impact to some degree on how our government functions. And primarily it is, in this moment, the head of the Senate Majority Leader, who is taking legislation, bipartisan legislation coming from the House, and under the auspices of calendaring it, not bringing, and he's not the only one who's done that, but not bringing it to the Senate, basically stalling bipartisan legislation that's by the people, for the people, we the people, and saying, you know what, I'm just going to put a stopgap on that. And that is, that's not the president. That's not Congress. That's not a federal judge. And I think that that's something that is poorly understood. That is an artifact of procedural rules that has a tremendous impact on the separation of powers.
All right, let's move to a couple of other aspects of the pandemic that I think are on people's minds. Let's ask about vaccinations. We hope that someday there'll be a vaccine for the coronavirus. Can government compel citizens or individuals to submit to a vaccine? Is that well established in law?
Very clearly. It's been for more than 100 years. It started during smallpox. And I think the point is that our liberties are not unlimited. We don't have the ability to say, I'm going to infect my neighbors. So certainly there's a fact specific thing on, what we want to know about the vaccine, but certainly as a matter of baseline law, mandatory vaccinations are certainly, perceived to be fully constitutional.
Garrett?
But let's Mike is absolutely right about the case law, but precedent seems very like a slender reed to me. And I think it's important to remember that in 2012, when the Obamacare case came before the court, the opponents who won quite a lot from that court told the court in response to a specific question that neither Congress nor the president would have the authority to order vaccination. They said, no, that's purely a local matter. So that lets you know how extreme the theories are, because that position got 4.5 votes. I hope that the justices would see reason, but.
Well, in that case, 1905, the Jacobson case, that involved a state law requiring vaccinations.
Yeah.
Maybe there's wiggle room between a federal vaccination and a state vaccination, but it would seem we won't know who will be president when we do get a vaccine, hopefully sooner rather than later. But if it's President Trump, the expectation would certainly be any law, unless it came from Congress, he might not even, he might veto that or refuse to sign it. That would probably be implemented by the states.
So notwithstanding that early 20th century precedent, do we think that the current courts would give more weight to a religious objection? There are some religions that don't like vaccines. And of course, there seems to be a growing skepticism about vaccines, some of which is religious otherwise. Is that going to carry any weight, religious-based objections to vaccines?
As Professor Wehle put it a moment ago, there's always a balancing test. So I think and now Garrett could be right, and everything could be like the court just doing what they want politically. But if we were all playing an honest game, then I would want really good evidence that there was an absolute need to protect the population, to have everybody vaccinated, and that there was no other way to do it. I think you'd need to prove that there was a really good reason for it.
But let's remember that at the state level, there is presently no constitutional requirement to allow religious exemptions. And Mississippi, for example, of all places, doesn't allow it because they say, look, the point of a vaccination is to stop the disease. And if we let people opt out, we're not going to build up the immunity that we need. So right now, there's no case law requiring this exemption. This court is unbelievably favorable to religion, particularly majority religions. And so who knows? But at present, you know, the law is as Mike describes.
Well, so is our Attorney General. I mean, the Justice Department in these cases about, you know, in a case in the South regarding drive-up religious services, filed a brief on behalf of the plaintiffs. They've issued sort of guidance that they're going to be tough on any burdens on religion. So that's an emphasis of this particular Justice Department. This Justice Department has not emphasized ensuring that there are not, you know, systemic constitutional violations going on in police departments, for example, as compared to prior presidents. But that is a priority. So I would suspect that again, if we have this, if President Trump is president and Attorney General Barr is the Attorney General, when the vaccine is rolled out, religious objections will be taken very seriously by the Justice Department.
Yeah. How about quarantines? That's another step that has been discussed. If we have more contact tracing and we determine who has the virus and might be contagious, some governmental authorities, state or federal, say you must stay at home. Is that well established that government can do that?
Well, it's the same case. It's the Jacobson case, the 1905 case. And as Mike mentioned, it's a balancing test. So it has to be non-arbitrary, can't be discriminatory, and it has to actually be tailored to the interests of serving public health. So coming in and saying you need to stay home for the next 6 months just to make sure that we get every last case of COVID, that would certainly be a problem. But given there's a ton of epidemiological research about what to do about this particular virus, and not only stay-at-home orders, but also contact tracing and heavy testing makes a significant impact. And that's what we haven't had in this country that other countries have had. This isn't a conundrum as far as how to solve it as a public health matter. This is just a lack of political will or conflict or, you know, balancing of other things that has really cost lives.
But we do have interesting issues like where Delaware has police officers not letting people from Maryland drive off the highway. I mean, the question then becomes what I said earlier about equal treatment, which is, can a state really block itself off and keep out-of-staters from coming in? And that goes back to what I think Professor Wehle was saying a moment ago, which is how much evidence do you have? Is there really a difference between a Marylander and a Delaware resident in terms of walking on the beach in Bethany?
And of course, there you've got a right to travel too. That's not expressed in the Constitution, but the court has recognized it under the Privileges and Immunities Clause, although it's not unlimited, right? So you can't be taxed for leaving the state, but whether in a pandemic, Delaware could stop you at the border or inched across the border where you're on Delaware property. I think they have a pretty good argument that you should just drive around.
And let's come back to voting. We touched on it briefly before, and we'll have a separate session on it, but it's so important. There is a challenge to California's mail-in voting procedures. And mail-in voting seems quite necessary, at least at the moment. How do you predict that case will come out? Kim, you're our voting expert for the moment.
Yeah.
You confident that California's procedures will withstand scrutiny?
Well, I mean, I've looked into this, and there are actually 27 states where there are challenges pending right now in court to COVID-related changes leading up to the November election. So here's another situation where we are going to see courts, not legislators, not elected officials, deciding issues that are meant to really be done by legislators. As Garrett mentioned, states decide voting procedures. Congress can kind of come in and do things like the Voting Rights Act. there is no constitutional right, express right to vote in the original Constitution. The court has inferred a right to vote, but like everything, it does not give it the highest level of scrutiny. But again, we've got a balancing test here, and the test has to do with how the interest of the state and the burden on the voters. And given that you could end up in the ICU or worse if you get COVID at the ballot box, I think there's a very strong argument that these procedures should be upheld. Some of these these cases have been brought by Democrats. Some of them have been brought by Republicans. But there are 5 states, including Utah, which is a traditionally Republican state, and Oregon, as Garrett knows, where they've for a long time had all mail-in elections, and we're not seeing massive amounts of fraud. The sort of fraud through voting is a myth. It's virtually non-existent, and it's not one of those things where we have many beans on the countervailing weight when it comes to this precious right to vote, which is really, although it's not in the Constitution, it is the heart and soul of everything else in America.
I want to, we're 6 o'clock, but we're going to go a couple of minutes longer if our audience is still with us, because it's so interesting and I appreciate the insights. Garrett, there was a flurry of litigation in Wisconsin earlier in the primary season over voting there. How do you see that litigation?
Well, I think anybody who is hoping the federal courts will protect our right to have a fair election that is functional is really should be sobered by what happened in the Wisconsin case, because we were at the height of the lockdown, the COVID pandemic. The governor ordered the election to be held by mail, and the mail-in ballots to be counted, and everybody to get one who wanted one. And the Supreme Court, 5-4, partisan lineup, set aside that order. And again, an opinion by Justice Kavanaugh, who is shaping up to be a prize package, it basically changed the facts and said, Wisconsin law provides X, Y, and Z, which it was just making up, and basically said that you have to go ahead with the in-person election. We are seeing an uptick in cases in Wisconsin, by the way, after that primary. So,
cases meaning COVID cases, not litigation, but COVID cases.
Yes, yeah.
At least
in actual
50 that were traced
illness.
back. That when I last looked, at least 50 confirmed cases where people were infected by virtue of having to go to the polls. And that case is an example of where we see the Supreme Court jumping in and interfering with the prerogative of a particular state when it really did not need to. And I read that opinion a few times. I think it's a very tortured analysis and quite troubling.
Yeah.
I want to just say one other thing about the right to vote, which is the courts have treated it as kind of an optional low-level right, but the right to vote is the only right that is mentioned 5 times in the Constitution. And I think the courts would do well to give it a little more consideration than they have. Of course, judges aren't elected, so they don't see what's the big deal. That's just my own textual pet peeve.
All right, let me, we'll wrap up here, and I want to ask each of you to kind of put on to look at your crystal balls and figure out where we're headed with all this. I mean, at this moment, it feels like there are so many stresses on the Constitution, on our democracy, and our healthcare system. How does this all turn out? And I'm not asking you to predict the November election. I'm asking you to tell us whether the constitutional guardrails are holding up. Mike, you earlier called yourself an optimist. Why don't I start with you? Tell me if you think we're going to get through this period of American history and get to a better place, or are we heading into the depths?
Well, I've learned that my ability to predict is really bad. Nonetheless, what history teaches is that we have survived incredibly negative situations, whether it's the McCarthy era, whether it's the Civil War, whether it's a host of things that have put pressure on the Constitution. Sometimes we've done it very badly. Sometimes people have been killed or put in internment camps, enslaved. We are not a perfect society. But there's something that allows us, and I truly believe this in my soul, to largely muddle through. There is an essence that there's something beautiful about being free, about treating people equally, about liberty, about limitation on power that eventually seems to come to the fore. So I'm putting all my money on that trend in American history, that it's a long and tortured path, but we tend to get out on the other side.
All right, Kim, you're next. You, I think, are not such an optimist. If we're to speak generally, how bad do you think it's going to be?
Well, I don't know how it's going to be, but I think democracy, American democracy, is hanging on by a thread. I think November is a use it or lose it moment. If you want democracy for yourself, your children, and your grandchildren, you need to get to the polls and vote in a way that ensures accountability for our elected officials. I mean, I agree we've been through really horrible times, but of course, there's a number of reasons why right now is different. One is we've got foreign interference in the election and a global economy. Two, we have extraordinary polarization. We have Congress that's not functioning, rubber stamping in this moment what's happening in the White House. That is not a check anymore. And we can go through the levers of accountability that Congress functions: oversight, the Emoluments Clause, appropriations, investigations, the ability to get information. All of those are shutting down, which leaves us with voting. And then the last piece really is technology, the ability of people to get bad information tailored to them in their phones, which have all the information in the history of the universe in your hand. That is not something that I think we've seen before. You mentioned I work with CBS News. Certainly in the Nixon time, there were a few outlets. They had standards of conduct. They self-policed to make sure that they were fact-based. Some of them still exist, but politicians cared about what the Washington Post wrote or New York Times wrote or CBS said. Now with all of this misinformation deliberately coming, I think it really is a strain on government by we the people, because people don't understand fact versus fiction, and they don't also understand basic civics. So I applaud people for being on this call. Only a third of Americans surveyed in 2015 could name all three branches of government. And it's very hard to protect our functioning government if we don't even understand how it works and what's important. So I'm not hopeful, but I'm out on my out here as a cheerleader for the right to vote.
Well, a cheerleader and an educator.
Yeah.
Telling people what they need to know. Garrett, our friend, our colleague Kim Wehle, democracy hanging by a thread. What do you think?
I think that history shows us that no system lasts forever, and that a democratic system is hard to manage. It's hard to keep all the plates spinning. We now have a situation where one of the two major parties does not believe in democratic government. It doesn't believe in limited government. It doesn't believe in voting rights. It doesn't believe in civil rights. It doesn't believe in civil liberties. The strain of authority, this is not Donald Trump off by himself. He is the product of 25 years of authoritarian ideology growing up inside that party. And I don't know how you can keep a system going if that many people don't believe in it. The Constitution doesn't enforce itself. And the thing that makes it or has made it work during part of our history is that citizens wake up in the morning and they say, today, I want to live under a constitutional republic. And if they stop saying that, there is no operating mechanism that's going to correct that. So I do think November is important. I certainly hope the election is held and that it is free and fair. And I don't want to put a percentage on that, but I will end by quoting Robinson Jeffers, who said in one of his famous poems, "Meteors are not needed less than mountains. Shine, perishing republic."
Wow. Thank you all. This was such a great discussion. I'm very proud of this UB Law in Focus discussion series that we have now inaugurated. And our colleagues, Kim Wehle, Garrett Epps, and Mike Meyerson really did a great job of raising and answering questions and provoking great thoughts. Next Tuesday at 5 o'clock, we'll gather in this same Zoom space to talk about the culture of policing with Mike Higginbotham, Kim Neal, and perhaps others. And certainly we invite our audience to come back and continue to participate by asking questions. I thank you all for being with us. I thank our participants, And I urge everybody to stay safe and healthy and attentive to these important issues.
And thank you, Ron.
My pleasure.
Thanks, Ron.